So, if you are a working employee or a business owner, do stay on to watch the full video as it will be especially beneficial for you. Hi there, welcome to the first part of Privacy Ninja's data protection series. Today, we are going to talk about the 9 obligations of the PDPA, also known as the Personal Data Protection Act. What I will be sharing is not only mandatory for Singapore companies, but also data protection best practices adopted by businesses globally. My name is Andy Prakash, and here is some information about myself. I come from a cybersecurity and privacy-focused background. I am the designated data protection officer for various companies, and I have been featured on various news and media outlets over the past 2 years. I've performed live hacking demonstrations at Echelon. I've been invited to speak at Interpol World and corporate training for our clients. What is the Personal Data Protection Act? Basically, the PDPA is a data protection law that is made up of several rules governing the collection, use, disclosure, and care of personal data. It recognizes two parties, one, individuals, and on the other hand, we have the businesses. Okay, so for you as an individual, the PDPA aims to give you more control over your personal data. One such benefit is that it allows you to access and correct your personal data. Another would be to reduce unwanted telemarketing messages. And for businesses, the PDPA governs how they collect, use, disclose, or store personal data, and this can only be for legitimate and reasonable purposes. So when and why does PDPC step in? Okay, PDPC stands for Personal Data Protection Committee. So firstly, we got to understand that the PDPA is a complaints-based regime, which means anyone were to make a complaint to PDPC has to step in and perform an investigation. So across these 4 points, these are the typical scenarios whereby why someone would want to complain to PDPC. We'll take a look at the first example, customer complaint. There may be a scenario whereby a customer is unsatisfied with his personal data queries, or maybe he or she is not getting back clear replies regarding his personal data queries. So he can make a complaint to PDPC. Secondly, whistleblowing. It's possible that an employee is unhappy or uncomfortable with how the HR is handling his or her personal data, or he's not comfortable with how the company is processing their customers' data. Okay, another possibility is due to business competition. Maybe one of your competitors would have too much free time on their hands, and of course they want to take down all other competitions, right? So one way would be to complain to PDPC. And what can they complain about? Maybe they can go to your corporate website's privacy policy and search for certain items, certain clauses that needs to be publicly made available. And if it's missing, okay, you can make a complaint to PDPC to maybe try to get you into some trouble. And last but not least, data breach. This may be due to external malicious hacking incidents, or maybe accidental internal disclosure to the public or to other customers. When was the PDPA effected? The latest version is in July 2014. So let's take a look at the chart over here. At the start of the timeline, in October 2012, the Act was passed by Parliament. And then just 3 months later, in January 2013, progressively, the provisions relating to the formation of the PDPC was approved. Followed by exactly a year later, provisions relating to the DNC registry came out. And then 6 months later, the main data protection rules came out. What is covered under the PDPA? Personal data in Singapore is protected under the PDPA. And to take note that business contact information is not, also known as BCI. So let's take a look at personal data first. Okay, personal data can be electronic and non-electronic data. Okay, be it whether it's true or false data. And also for deceased individuals, okay, for someone who has passed away, the disclosure and protection rules can still apply for up to 10 years. So that's personal data. Okay, what about BCI, business contact information? Okay, this is basically any information that you provide that is not provided solely for personal purposes. Okay, most commonly, how we inform this to people is that BCI can be any information found on your business name card. For example, even if your full name, your personal mobile number, your personal email address, okay, your office address, it's on your name card, okay, these will all fall under BCI. So if it's for a business to business transaction, okay, this doesn't fall under the PDPA. So let's take a look at what exactly is personal data. Personal data is any information, okay, that when provided would be able to accurately identify an individual. Okay, this can be someone's full name, his NRIC or FIN number, personal mobile telephone number, or passport number. Okay, this can also be his photograph or video image and voice recording. Okay, bio identifiers like iris image, DNA profile, and thumbprint. Even though these are not common, okay, but it's very straightforward that this would help someone accurately identify someone. Okay, of course, we also have someone's email address, residential address. So any of this information, okay, in part or when put together, and there's a data breach or accidental disclosure, okay, that would fall under PDPA. How does it affect individuals? So firstly, individuals are expected to take ownership and responsibility to manage their personal data. Okay, so these are the following points, okay, that individuals are expected to know as well, okay, regarding the PDPA. So firstly, providing consent. Organizations have to inform you why they are collecting your personal data and seek your consent before collection, using, or disclosing your personal data. If you willingly provide your personal data, you may be providing deemed consent for them to use your personal data. Okay, you should also know what personal data to provide. Sometimes it may not be necessary for you to provide your personal data, and organizations cannot force you to agree to the collection, use, or disclosure beyond what is reasonable to provide you a product or service. You should also know that you can withdraw consent. Okay, so you can tell an organization to stop collecting, using, or disclosing your personal data. The organization should inform you of the likely consequences, okay, of your withdrawal before processing the request. However, they are not required to delete or destroy your personal data, and they can keep it, okay, they can retain it for as long as there are business or legal reasons. Requesting access. So any individual can request to see the personal data that an organization has about them, and also check how that personal data has or may have been used or disclosed in the past 1 year, okay, leading up to that access request. Organizations can levy an administrative fee for each access request, or even reject the request if it's considered frivolous. Okay, and last but not least, requesting correction. You may request to correct an error or omission in your personal data held by the organization. Unless the organization has a valid reason not to make the correction, it should correct the data and send it to organizations which have received it in the past year, or if you agree, only to specific organizations. So now that you have learned what are your rights as an individual under the PDPA, we'll be taking a look at how the PDPA affects businesses. So this is where the 9 core obligations and the DNC provisions step in. Okay, we'll take a look at this data lifecycle. There are 4 main sections. You can see over here at the time of collection, followed by during usage, followed by how you dispose or store personal data, and who you disclose or transfer personal data to. Okay, on the outer ring, these tags are the 9 obligations. Starting with the first obligation, consent, your business can only collect, use, and disclose the personal data of individuals who have consented to such collection, use, or disclosure. Okay, purpose, okay, your business can only collect, use, and disclose personal data for individuals for the purposes for which consent have been given by those individuals. Followed by notification. Okay, again, your business must inform individuals of the purposes for which their personal data is being collected, used, and disclosed. So all these 3 obligations, okay, will fall during the collection period. And what about usage? So there's the accuracy obligation. For accuracy, your business must make a reasonable effort to ensure that the personal data collected by the business is accurate and complete. Okay, if the personal data is likely to be used by your business to make a decision that affects the individual, okay, to whom the personal data belongs to, or if this personal data will be disclosed by your business to another organization. And the next part, storage and disposal, we have the protection obligation and the retention limitation obligation. So, for the protection obligation, your business must put in place reasonable security measures to protect the personal data in your possession or control. Okay, this will be to prevent risks such as the unauthorized access, collection, use, and disclosure, okay, of such data. And then we have our retention limitation. For retention limitation, here a business should retain the personal data for only as long as necessary, okay, for any business or legal purposes. Okay, no such thing as you can keep the personal data for as long as possible, and then in time, maybe if you plan to sell your business, okay, the more data you have means the more valuable your company is. Okay, this can no longer happen. Moving on to disclosure and transfer. Okay, we have our access and correction and our transfer limitation. So for access and correction, okay, your business is obliged to provide information to individuals upon their request and as soon as reasonably possible. Okay, so what you've got to reply them is what personal data of theirs, okay, is in your possession, under your control, and how such personal data has been used or disclosed to who within 1 year, okay, commencing from the date of the request. And transfer limitation. Okay, if your business is transferring the personal data overseas, such as storing the data in the cloud, okay, you got to ensure that the transfer meets the PDPA's data protection requirements. Okay, why? This is to ensure that the data being transferred is offered a comparable level of data protection, okay, that as is provided by the PDPA. Okay, and then we have our accountability obligation. Previously, this was termed as openness obligation. Okay, as of July last year, this has now been renamed to accountability obligation. So if your business, okay, under accountability obligation, you must implement the necessary policies and procedures to fulfill its PDPA obligations. And you must make information about such policies and procedures publicly available. And also, for example, your data protection officer's business contact information must be made available so that people, okay, can contact your DPO, okay, to find out about your policies and your access requests and complaints handling processes.